try to do, excuse me, as best I can, is to move the camera from party to party as they're talking to you, okay?
Great, thank you.
All right, thank you. So the doctor has filed her report some time ago on November 9th, 2020, and the defense is contesting her conclusion. So, Ms. Ginsburg, if you would go ahead with your witness then.
Thank you, Judge. And before we begin, I just want to confirm that defense counsel is not objecting and is stipulating to the doctor's verifications as an expert.
That's correct.
Okay, the court will note that there are no Daubert type challenges to the expertise of the doctor, and that her qualifications are of record. Thank you.
Thank you. Dr. Kuzaki, how are you employed?
I'm employed as a licensed psychologist at Mendota Mental Health Institute.
And how long have you worked there?
Sorry, I'm having a hard time hearing.
You can take your mask off if you feel comfortable, Ms. Ginsburg. Have you been vaccinated?
I am.
You have, great. All right, thank you.
Dr. Kuzaki, can you read better this way?
I still can't hear her for some reason. I'm sorry.
I don't know. I mean, I've got the volume turned up.
I can hear she's saying something. I just can't hear what she's saying. I'm sorry. I can hear you, Judge.
Should I try to do this microphone? What about the one next to it? Better idea, Cheryl. Is this microphone any better?
Yes.
Is okay.
Okay.
How long have you worked as a licensed psychologist?
I've worked as a licensed psychologist at Mendota since September of 2020.
And are your job duties to they include formal competency evaluation?
Yes.
Did you have an occasion to conduct a competency evaluation of Mr. Ramiro Roman Vieira?
Yes.
And did you write a report detailing that evaluation?
Yes.
Was that dated November 9th of 2020?
Yes.
And it's about 12 pages in length.
Yes.
Do you have a copy of that with you to reference?
I do.
Did you meet with Mr. Roman Vieira in person?
Yes, I did.
And what was his general demeanor throughout your meeting?
Sure. So throughout the meeting for the evaluation and at other times when I met with him, Mr. Roman Vieira was agreeable to meeting, but he demonstrated a limited engagement in discussing the competency materials and providing information. And when completing the psychological testing, he demonstrated poor effort.
And have you informed him of the purpose of meeting with you?
At the time of his admission, I had informed him that I would be conducting the evaluation. And yes, at all times I met with him, I did provide him with the reason for whatever meeting we were having.
What were sources of information that you used in your analysis of Mr. Roman Vieira?
Sure. Some of the sources of information included his medical records from his admission to Mendota. I also reviewed records from the Milwaukee County Jail. I reviewed Wisconsin CCAPs and other DOC records as well. I reviewed the current criminal complaint and other court documents. I also reviewed a previous competency evaluation that was dated October 16th. And I also conducted psychological testing with Mr. Roman Vieira, and I consulted with his psychiatrist on numerous occasions.
And why is it important to review additional sources when you conduct a competency evaluation?
I'm sorry, could you repeat that?
Yes. Why is it important for you to review additional sources of information in conducting competency evaluation?
Sure, so it's important to review all the different sources of information in general to get a better understanding of someone's history and their clinical picture. With Mr. Roman Vieira specifically, it was also important because he had claimed that he could not recall a lot of information. And then his records from Milwaukee County Jail provided useful and detailed information regarding his abilities and his presentation, which was inconsistent with those at Mendota and during my eval.
The last part, can you repeat the last sentence?
And my eval, sorry.
And, okay, thank you.
Was Mr. Roman Vieira diagnosed with any mental health disorders?
Can you repeat that again? Sorry.
Was Mr. Roman Vieira diagnosed with any mental health disorders?
At Mendota and in my evaluation, I did not assign a diagnosis.
Did Mr. Roman Vieira exhibit an understanding of charges against him?
He claimed to have no knowledge, but throughout the eval and the course of the evaluation, he did demonstrate that he in fact did know his charges and details surrounding those charges.
And did you speak with Mr. Roman Vieira about various plea options in this criminal case?
Yes.
And did you speak about consequences of the plea options?
Yes.
What was your, or how did you find that he was able to exhibit an understanding or no understanding?
For what was the last part?
Did you find that he could understand the pleas or not?
Yes, yes, that he could understand them.
And I want to be just clear, did Mr. Roman Vieira state he understood them, or was that he felt he demonstrated knowledge?
So he claimed that he had never heard these plea options before, but then when having a discussion about prior experiences, he was able to discuss ways in which he pled before. And when talking about them, he did at times claim that he didn't know that information. But again, during additional conversation, he did demonstrate a knowledge.
Did Mr. Roman Vieira demonstrate an understanding of the adversarial nature of criminal proceedings?
Yes.
And based on your knowledge, skill, experience, and training, did develop an opinion to a reasonable degree of professional certainty regarding Mr. Roman Vieira's competency to understand criminal proceedings?
Yes.
And did you come to that same reasonable degree of professional certainty regarding his ability to assist in his own defense?
Yes.
And what is your opinion?
What is my opinion, did you say?
Yes.
I offer the opinion to a reasonable degree of professional certainty that Mr. Roman Vieira did not lack substantial mental capacity to understand the proceedings and that he can assist in his own defense.
What is the basis for your opinion?
Sure. So the basis for my opinion, even though he did not answer many of the questions or claimed no knowledge, he did demonstrate a knowledge and understanding. He demonstrated knowledge of legal concepts, but clearly stated during the evaluation that he was not interested in learning them. During the evaluation, his presentation was inconsistent with his history and his abilities as well.
I'm sorry, his recitation was inconsistent with his history?
Yes.
Okay, thank you.
And I also, as part of in my report, I used another method called a parallel assessment. And that's specifically looking at someone's abilities outside of the context of the evaluation. And so in looking at these different behaviors, we also associate them to functional abilities that relate to competency to stand trial. And based on this, Mr. Roman Vieira's memory, motivation, reasoning, problem solving, all of those things establish his ability, or suggest competency as well.
And so is it your opinion that Mr. Roman Vieira possesses the present ability to consult with his attorney with a reasonable degree of rational understanding,
Yes.
and that he can substantially aid in his own defense at this time?
Can you repeat that? I'm sorry.
Is it your opinion that Mr. Roman Vieira can substantially aid in his own defense at this time?
Yes.
Judge, I asked to admit the report that was authored into evidence for purposes of this hearing. I believe the doctor had been referencing it as well.
Any objection?
No,
Okay, thank you, Mr. Fenton. That would be the court will just take judicial notice. The report has already been filed. It's in the docket as document number 70 in our case. And I'll take judicial notice of it at this time. All right, does that conclude your direct examination?
Yes, thank you.
All right, thank you. Mr. Fenton?
thank you. First of all, doctor, can you hear me okay?
I cannot, sorry.
Judge, I know what I'm asking as well.
If you feel comfortable, you may.
Doctor, can you hear me a little bit better now?
Yes.
Okay. So when you met with Mr. Roman Vieira, those meetings took place at the mental health?
Yes.
How long was Mr. Roman Vieira at Minnesota?
Mr. Roman Vieira was, I'm just checking my report, was admitted on October 28th. I would have to double check about the discharge date, but I don't know his discharge date off the top of my head, but as of 14/2, it's within those 14 days.
And during that time period, how many meetings did you have with Mr. Roman Vieira?
Sure. I met with Mr. Roman Vieira. I attended his admission staffing, which is members of his treatment team on the day he was admitted. I also did the competency evaluation on November 6th. And I'm just, let me look at. I'm looking at the testing. And then I also met with him on November 4th to conduct psychological testing.
Okay, so you had 3 personal interactions with Mr. Roman.
Yes.
You testified on direct examination that you claim to have no knowledge of the charges in the case against him, that he lets the information suggested that he did understand the charges.
I'm sorry, I can't hear you.
Sure. So on direct examination, you testified that he claimed to have no knowledge of the charges against him. Is that correct?
Yes.
But you believe that he was letting slip information suggesting that he wasn't.
Sorry, I can't hear you again.
I don't understand the question. I mean, if you could rephrase it.
During your interactions with Mr. Roman Vieira, you believe that he did understand the charges. Is that correct?
Yes, Mr. Roman Vieira stated his charges to me.
Was he able to list all the charges or some of the charges?
Mr. Roman Vieira stated, as on page 8, he responded first-degree sexual assault of a child.
Did he appear to struggle to remember what that charge was?
No.
Did he recall any other charges pending against him?
Can you repeat that?
Did he state any other charges that were pending against him?
I only asked him about the current case, but he was able to discuss his prior legal involvement.
In your evaluations of Mr. Roman Vieira, did you perform any tests to determine if he was suffering from Alzheimer's or dementia?
So there was nothing indicated in his history that he had any difficulties with his memory or throughout the course of his admission beside his self-report. He did state that he couldn't recall any information of his history to us. Previously, he was able to provide this information. Because of his claims, I attempted to.
Go ahead. Go ahead.
I
I'm just letting the victim witness person in.
I attempted to initiate psychological testing, and the one test that I did complete is included in this report. Typically, we start with that measure as an effort measure, and had Mr. Roman Vieira put forth adequate effort, I would have continued to do other testing.
What specific behavior
I'm sorry, can you repeat that?
Why do you believe he was not putting forth adequate effort in psychological testing?
Sure. So on that, so the TOM, the test of memory malingering, this is a test that we use. Just going to that page. Hold on. So it's a visual nonverbal recognition test to assess for between feigned and true memory impairments. And so when it's specifically sensitive to malingering and also factors such as if there was a memory issue. So because of the nature of this test, individuals who are putting forth effort and answering honestly would be expected to make very few, if any, errors. So this is each trial is out of 50. And on the first trial, he scored a 16 out of 50. And on the second, he scored a 16 out of 50. So based on these scores, even individuals who have genuine memory impairments, the majority of them still score above a 45 on trial 2. So it was, his scores indicate that he actually, sorry.
Doctor, I'm sorry. Can you just repeat the last part? Where did you lose her? 45. Oh, the score.
So based on his score, those cutoffs would indicate that he did not put forth effort. And in fact, those scores indicate that Mr. Roman Vieira, when presented with the images, he knew the correct answer and intentionally chose the incorrect answer.
Okay, thank you.
So you talk about this TOM test, can you just explain what that is?
I'm sorry, I can't hear you.
Can you explain what the TOM test is?
Sure. So the TOM is test of memory malingering. It's a 50-item visual nonverbal recognition test. It's developed to help distinguish between feigned and true memory impairments. And so this measure, again, it's sensitive to malingering and is relatively insensitive to factors such as intellectual disability, neurological impairment, traumatic brain injury.
You dropped your voice at the very end. Can you just repeat the last part?
Sorry, or traumatic brain injury. And
yeah, let her finish her and repeat her answer.
And as mentioned, we tend to use this when we're going to do testing as our first measure because it also is an effort measure.
Thank you.
And how is the test conducted?
I'm sorry, can you repeat that?
How is the test conducted?
I can't hear him again, sorry.
How is the test conducted?
Sure, the test is conducted in person. There are 2 stimulus books that contain 50 images, very basic images. And Mr. Roman Vieira, as I flipped through them, he points to the one that was shown to him.
I have nothing further this time.
All right, thank you. Anything further from the state, Ms. Ginsburg?
No, thank you.
All right. Hold on. All right, thank you. Can the doctor be released from her subpoena and excused?
Yes.
Yes, okay. Doctor, again, thank you very much. We are grateful to you for your testimony and for your work, and you're excused from the meeting.
Thank you. I'm sorry about the hearing difficulty.
That's all right. Some days
Thank
it's good, some days it's a little funky.
Yes, thank you. I appreciate it. Have a good one.
All right, thank you. All right, and Ms. Nguyen, since you're not here for this case, I'm gonna just put you back in the waiting room if that's okay with you. Okay, thank you. Ms. Nguyen is a victim witness advocate from the DA's office, and I thought perhaps she was here on our case, but she is not. So, Ms. Ginsburg, does the state have any further testimony or witnesses?
No.
All right, so the state has nothing further. Mr. Fenton, do you have any evidence or testimony that you would like to present?
No.
All right, are parties prepared to make their arguments then?
Yes, sir.
Okay, I'll hear from the state.
Thank you, Judge. The state is asking the court to adopt the findings of the doctor's report and testimony here today. We are of the opinion that Mr. Roman Vieira does not lack substantial mental capacity to understand the proceedings, that he can assist in his own defense under Wisconsin statute 971.14, subsection 4. The state must prove by the greater weight of credible evidence that the defendant does not lack substantial capacity to understand the proceedings or assist in his own defense. I believe that the testimony that was taken today in conjunction with the report that is part of the court docket, that evidence has been met to that burden. The doctor testified to the sources of information that she reviewed in before conducting this competency evaluation with Mr. Roman Vieira, and those sources of information proved to be useful and necessary when she was considering his history, especially as she stated, because he claimed having recollections, and those were demonstrated to be not true. It was demonstrated to the doctor that he had knowledge and an understanding of the criminal proceedings, specifically the rules, the possible pleas and outcomes and consequences, and the way that a trial would work. Part of that was that he had pled in a case before, even though he claimed he did not understand pleas, claimed that he had never heard of specific legal analysis, things such as the pleas, and that he had demonstrated he had implemented before. As the doctor said, the records from the jail provided useful information because it showed that it was inconsistent with how Mr. Roman Vieira was trying to portray himself in this hearing. She also mentioned the fact that he had an interest in learning about the competency evaluations during her testimony on the cross. The doctor did use the word lingering when referencing his memory, and I believe that that is a phrase that's best describing the entirety of how Mr. Roman Vieira was answering and trying to sound as if he was not competent, although through the testimony, it was demonstrated that he was competent. The doctor that has testified has been a licensed psychologist for a number of years. She's an expert, and I believe that from all of her testimony and her reports, it's been proven that specifically this defendant, Mr. Roman reasonable degree of medical certainty that he can proceed and aid in his defense. So I am asking that the court adopt the doctor's findings and reinstate proceedings.
All right, thank you. Mr. Fenton, before I hear from you, you know, we're so disjointed with all the moving around of courtrooms and change of procedures. I neglected to ask your client outright directly whether he does challenge the findings of the doctor's report. I think I did that on the last date, but let me ask him again directly. All right, Mr. Roman Vera, I have to ask you whether you claim to be competent or incompetent. What is your answer? Can you answer me one way or the other? I'm sorry? You don't know the answer. Okay. Okay. I will take that as a claim to be not competent, Mr. Fenton. Go ahead.
Thank you, Your Honor. As the court just saw, Mr. William here was unable to answer a pretty basic question regarding whether or not he is competent or incompetent. And the court that he's unable to really engage with the medical staff in the lower health. He often struggles to understand terms and it's all for his grade often. Struggling to remember these things. And for what it's worth, that's consistent with the interaction mechanisms that is often unsure of what's occurred in the past in this case. Very forgetful, unable to remember what's going on. He very heavily within the report that he often struggles to answer basic questions from staffers having no mental health, often resorting to simple thing he doesn't know certain things. So I think based on those interactions with Mr. Williams, he is not confident to proceed. I would ask the court to reject the conclusion of the report and have him be sent to manufacturing the health and competency restoration treatment due to the fact that he is currently unable to remember anything about the past of his case and therefore unable to assist in counsel or be able to aid in self-defense. But for those reasons, Your Honor, I am asking the court to issue the finding not competent as it is in total at this time. Thank you.
All right, thank you. Well, the court always in these situations begins with the requirements of the statute under 971.14 sub 4. The court has conducted a hearing based upon the proceedings thus far. I've received the report. I've asked the defendant whether he claims to be competent or incompetent, and the defendant really did neither. He did not stand mute or he did not claim to be incompetent, but I did then take his response as a position that he is not competent to proceed. Therefore, the state has to prove by the greater weight of the credible evidence that the defendant is competent in order to continue with the criminal proceedings, or the proceedings are suspended and the defendant proceeds for restoration of competence. I say restoration of competence because there is a lengthy history in this case. We started this matter in 2018. It started before Judge Sanders. There were numerous appearances. It was filed in September 2018. And first, the defendant was represented by Caitlin Fear. Next, the defendant was represented by Attorney Mark Lipscomb as an appointment from the public defender. Mr. Lipscomb remained on the case. Until December 20th, 2018, where the court had a colloquy with the defendant. The defendant wrote letters to Judge Sanders. Document number 10. Your Honor, I'm humbly requesting the termination of my attorney, Mark Lipscomb. I've repeatedly asked Mr. Lipscomb Jr. questions regarding my case, but he is not trying to communicate effectively toward my situation regarding my case. Mr. Mark G. Lipscomb Jr. has not come up with nothing or any strategy to help me out. I believe Mark G. Lipscomb Jr. is not representing me to the best of his ability. I hereby request a different attorney. And then signed by Mr. Roman Vieira. So after that, Attorney Carrie Cleghorn was appointed to represent Mr. Roman Vieira. Things went forward. Case was the subject of various pretrial proceedings. And then in May 13th of 2019, the defendant again wrote to Judge Sanders correspondence entitled, quote, ineffective assistance of counsel and misconduct, end quote, where he accused Attorney Cleghorn of some kind of misconduct. This is a 3-page handwritten letter, again signed by Mr. Roman Vieira, making allegations about appointed counsel and her investigation and her duties. Attorney Cleghorn moved to withdraw. And on May 17th of 2019, the defendant refused to be escorted to court, and then the judge ordered that he appear, and somehow he appeared with the assistance of the sheriff. Again, Mr. Roman Vieira wrote to the judge July 3rd, 2019. He again is complaining about Ms. Cleghorn and her representation. And again, counsel moved to withdraw. And on July 8th, Judge Sanders allowed Ms. Cleghorn to withdraw. New counsel was appointed in August of 2019. That was Attorney Russell Jones. An amended information was filed. An arraignment was conducted. Final pretrial was conducted. Mr. Roman Vieira was in court with this court in August, in December, in January of 2020. In January 24th of 2020. And we conducted a plea hearing with Attorney Jones and Mr. Roman Vieira on January 24th. Sentencing documents were filed. Mr. Roman Vieira made another appearance in court in February of 2020. He made a Zoom appearance in May 29th. And before that, he filed a pro se notice of motion motion to challenge jurisdiction. Again, handwritten and very cogent. On June 10th, he wrote to the court, or signed a request for his records that contained a handwritten request to the clerk of court. And by June 18th, Attorney Russell Jones filed a motion to withdraw. And the basis was that for his motion to withdraw was, quote, the grounds for this motion are that the defendant has specifically indicated to counsel in no uncertain terms that both he wants new counsel and desires to withdraw his guilty plea, end quote. That was on June 18, 2020. Then the defendant brought his own motion for reduction of bail on June 23rd, 2020. A 7-page document that was filed with the court. On July 2, 2020, this court allowed Mr. Jones to withdraw. On July 10, Mr. Roman Vieira made a complaint to the chief judge about this court not being mindful of holding defendants under certain bail conditions. July 15th, the defendant wrote to the court again, asking for a signature bond. The letter is dated June 4th, but it wasn't filed until July 15th. The defendant on July 15th also filed a handwritten motion to challenge personal jurisdiction, 2 pages. Mr. Fenton was appointed to represent the defendant about July 14th, the middle of July. And then, lo and behold, on August 25th, 2020, Mr. Roman Vieira, while awaiting sentencing for the very first time in 2 years, raised competency, or it was raised on his behalf. While all this was going on, Mr. Roman Vieira, on January 4th, this was filed, dated December 11th. And Mr. Roman Vieira, I have to tell you, this sounds like a very competent person writing this letter. It says, quote, Your Honor, Stephanie Rothstein, I decided to fire my attorney, Jay Fenton, due to the fact that my attorney, Jay Fenton, has not been helping me out with legal matter. I did file a complaint to the Office of Lawyers Regulation to have my attorney to be removed from my case. Sincerely, Ramiro Roman Vieira. That's public record. That's in the docket. And it's signed, and it bears the same signature that have been on all of the correspondence that this court has received from Mr. Roman Vieira since the beginning of this court's involvement with this case. So the court considers that correspondence. I think it's appropriate and right, and it's not unfair surprise to anybody because it's in the docket, it's in the record. The defendant wrote those things and filed them with the court as recently, as I said, as January 4th, 2021, while this competency contest was pending. The court also notes that the doctor's report is extremely important in terms of her evaluation. What she reviewed. She reviewed clearly 9 different items that are stated on page 102 of the report, ranging from his criminal history to competency reports done by other mental health professionals, that is Dr. Janis and Dr. Janis and Dr. Gable, Goebel. The court also finds it important to note that in the 14 days or so that Mr. Roman Vieira was at the hospital, I believe the doctor said she attended him 3 times. The initial staffing, his evaluation, and I think one other time after that. Am I correct, Mr. Fenton? It was the 3rd time, right? Or you have only
November 4th, November 6th,
28th, right? Thank you. So 3 times in 14 days is kind of a lot of interaction for the doctor to have at least made some observations about him and being able to make some conclusions. Especially interesting are the observations that are set forth on page 4, that the defendant wants to go to Mendota. Basically, he's afraid of the jail, is what I read between the lines. That he is worried about his mother, that he was soliciting information on Mendota Mental Health Institute. I note as an aside, this court's aware that Mr. Roman Vieira, I believe at the time the case began, was facing revocation, right? No?
I'm not.
Or is his sentence completely over? Ms. Ginsburg, do you know?
When this was filed, he was just on cash bail, so he did not have a hold.
So that old sentence is completely over. All right.
Judge, the entire time I've been assigned on this case, he's been at Milwaukee County Jail, would make it seem unlikely that he was involved. He was serving a revocation sentence, he would most likely be in the prison system.
Okay. Just to make clear that, it is very telling, and the court has rarely seen this strenuous of an opinion expressed by a mental health professional, as is expressed on page 5 of the report, where the doctor says, Mr. Roman Vieira, his score for feigning incompetency, in other words, pretending to be incompetent, fell well below the recommended cutoff score for feigned incompetency in adults. His score did not, however, fall below the range of scores expected to be obtained by random response. And then she goes on to talk about the really low percentage in the normative group and what people who were truly incompetent were likely to score. The last sentence is, as I said, I think strenuous for this kind of a report. Quote, this information provides evidence that Mr. Roman Vieira likely had little investment in demonstrating his true court-related knowledge on this measure. And that was the inventory of legal knowledge test. In fact, I know that Mr. Roman Vieira has demonstrated his inventory of legal knowledge in all the correspondence that he's previously sent the court, and as recently as the correspondence that he sent on January 4th, 2021, well after this interview took place. Dr. Gable was unable to rule out the possibility that Mr. Vieira was simultaneously feigning and incompetent, and so she, out of an abundance of caution, recommended this inpatient evaluation. The defendant, when he was on the unit, was not he didn't disturb individuals on the unit. He was compliant. He asked questions about how long he was going to be there. He was observed reading in his room. He submitted written requests to the staff. He asked for documentation from occupational therapy about how the competency process worked and how long he would be here for. He indicated that he read the materials that were provided to him, but claimed he still didn't understand it. The observations further of staff were that, quote, he appeared goal-directed in his behavior and verbalizations and had no difficulty advocating for himself, end quote. Again, on another occasion, he inquired about his competency evaluation, referenced his case, indicated that he was given the materials, and yet said he did not want to know what was going on, that he did not want to know or learn anything about the competency process. Staff notes indicate he was able to discuss previous legal involvement, including previous pleas he had entered. Yet he emphasized that he did not know or wish to learn the competency materials. During the interview on November 6th, the doctor reports that he was not fully cooperative in answering questions. He gave inconsistent answers, as she testified to, and revealed to him during their conversation that he does possess knowledge and understanding of the competency terms and that he's aware of his charges along with the potential outcome. The doctor reports that he was able to recite why he was at Mendota, what competency evaluation was all about. He did not want a criminal complaint and did not have a copy of the complaint, yet he responded that he was charged specifically with, quote, first-degree sexual assault of a child, end quote. He then put forward poor effort when it came to answering questions about the roles of individuals in the court proceeding. Claimed that previous attempts to educate him, quote, I never came around to stuff like that. It doesn't sink in, end quote. At the bottom of page 8, Mr. Roman Vieira was asked to define the term plea. He said he claimed to have never heard this term before and was unable to provide the 4 pleas, like guilty, not guilty, guilty by reason of mental disease or defect, and no contest. Yet this court observes that we had a lengthy plea hearing on January 24th, 2020. And I also think the timing of this competency challenge is important to note. That this competency challenge did not arise until after the various sentencing materials were filed. And based upon all the materials in this file, the court's previous interactions with Mr. Roman Vieira, the observations that this court has made about him as we have gone on through time in this case, the correspondence that I've received from him even after the competency evaluation, the conclusions of the doctor who has opined that Mr. Roman Vera does not lack substantial mental capacity to understand the proceedings and that he can assist in his own defense. Her findings that he identified his attorney by name. He detailed information about his life events. He exhibited poor effort. Based upon all of those observations and the testimony here, previous court proceedings, and his demonstrated behavior, this court is going to find that the state has proven amply and beyond the required standard, which is the greater weight of the credible evidence that the defendant is in fact competent. We will resume the proceedings. We will proceed to sentencing. And I know, Mr. Fenton, that you are asking to withdraw under the circumstances. The court is going to deny that request, and we're going to proceed to sentencing as soon as we can. Because this court, Mr. Roman Vera, has concluded that you are competent to proceed. You are here, and we're going to go ahead. I don't want to have any further problems in terms of your mental health in the jail. We want to make sure that you're competent. You're competent today, so we want to make sure that we continue these proceedings on schedule, so we don't have any lengthy delays. All right, anything further from the state at this time?
Not from the state.
Mr. Fenton, do you want time to file any sentencing memoranda or anything else?
Well, my concern right now is that part of our raising competency, the conversation I was having with the Roman were related to potentially pursuing a motion of the plea. In these running conversations in which I would it be possible for that first status in 2 weeks so I can have those conversations?
No. What I will do is give you till next Monday to file a motion if you want. Specifically only, the only motion that I'm going to entertain at this late date is a motion to withdraw the plea. And that will be due by 5 p.m. next Monday. The state will have an opportunity to respond. I don't know if a transcript has been filed, so
I requested that almost immediately after this employer
right, and I know that it's 40 pages long. So the court certainly, you've got that. So you're going to evaluate it. You're going to file your motion. If you find that there is a legal basis for it, the state's going to respond, and we'll set a date. Ms. Ginsburg, I'm going to just give you also a tight time frame, and your response will be due by the following Monday, which is April 5th at 5 p.m. And then we'll give you an in-person date sometime thereafter for any argument and decision. You want a hearing? If you want a hearing, Mr. Fenton, and you want to call witnesses, then you'll have to notify Madam Clerk. We'll set aside enough time, Madam Clerk, if we have an in-person date that we can use.
I'll reach out to the court what they did and when by email. Obviously, succeeding the state of that.
Before you file your motion, local rules require you to call the court to get a hearing date.
Okay.
So if we're going to change the date that we have, that we're setting right now, then you need to contact Madam Clerk first. Okay.
So we're setting this for argument and
Just
hearing.
argument and decision. And then if Mr. Fenton, we're going to allow enough time, but if Mr. Fenton wants testimony, he's going to have to let you know.
Okay, so on April 28th, which is the next available date for the person. And that'll be at 10 o'clock.
Okay,
Not a great meeting.
how about the 30th?
I can do May 4th.
Are we full on the 30th?
Yes, we have video, and so I will be in person afternoon, you have time to spot on.
Yes, yes, we're full. We're full. No more.
Yes. May 4th.
We'll go off the record if we didn't already. Thank you.
I can do 9 o'clock.
Ms. Ginsburg?
I would, and, travel. So, and then 9 was going to be. And really have to know.
How about 10:30? Cheryl, does that work for us?
Yeah, that's fine, but I want to get.
Mr. Fenton?
Yeah,
Okay, all right, we'll go back on the record.
So the next court meeting is going to be May 4th at 10:30, and that will be for in-person argument or decision. And we're going to be in file 2 of the safety building. And I'd like everybody to know that the filing of the March 29th brief needs to be emailed because I will be on vacation and will not see your filing until I get back on April 6th.
Okay,
Does that make sense?
so do both, in other words. That would be great. Thank you.
And then if I don't find.
Just an email to Madam Clerk and the state will suffice.
Okay.
Thank you.
Sense.
Yes,
All right.
thank you.
They will come to me for all my sense.
If you let us know early enough,
Okay.
it all depends on that, if Ms. Ginsburg will be able to make that arrangement with the victim, right? Okay. Okay, thank you very much. All right, that concludes our hearing. And then looks like we have some people in the waiting room.
That's for that added case.
Yeah, I guess we have Natalie, Maria, we have Sarah. And we have, who's in the jail? Oh, that's the waiting room that they opened for him. All right. Ms. Nguyen, welcome back. Ms. Hill. Now, we have somebody who's in the jail. Is that right?
That should be Ms. Ellis.
Yeah, I got Sarah. What's the story on that?
This is the witness in the